Stand up right now. Shake it off. Shake it out. Shake it out, shake it out, shake it out. We are going to talk about syndication. Yeah, baby. Welcome to the stage. My friend Todd Robinson. Get up here, brother. Awesome syndication attorney. He's going to tell you all about syndication.
All right. All right, all right. Hard to follow that one.
You're welcome, brother. There you go. Green button.
Okay, wait. Let's see. Oh, gotcha. Okay, how's everyone doing? Very good. What a weekend this has been. Man, I've had a lot of fun. I know you guys have. My name's Todd Robinson, founding partner of Robinson Fransman. We're a law firm based in Atlanta, Georgia. But we work with clients and syndicate transactions nationwide. Primarily a corporate and commercial real estate law firm representing multifamily investors, GPs, LPs, you name it. And we work with clients doing their first syndication, going from fix and flips to their first 2-3 unit apartment deal, all the way up to a 1,000-unit portfolio we're closing in Texas this year. This is a little bit of what we do: security services, real estate services, debt and equity services nationwide. We're kind of a soup to nuts law firm, so usually clients bring us the LOI and we handle the rest, whether that's through negotiating the purchase and sale agreement, working with your lender to get the financing secured, structuring the transaction, which is kind of our specialty, making sure you're compliant with securities regulations, and then going through title, escrow, and closing from beginning to end. Of course, I am an attorney, so I'm going to make sure there's a disclaimer here, right? What are we talking about? We're talking about syndication. Hopefully one thing you learned today is, what's the first rule of real estate investing? Other people's money. Somebody said it. Use other people's money. And that could be anybody. Well, not anybody, but that could be the bank. It could be sellers financing. It could be friends and family, institutional investors. It could be strangers now, even in certain circumstances, which we'll talk about a little bit later. But that's the purpose of syndication, right? That's using other individual investors to invest in your project, in your deal, and offering them a rate of return. What do you need money for? You know, we talked about acquiring the properties, and you guys have learned so much this weekend about how to do that, what goes into managing a property, what goes into acquiring a property. It's a full-time job, and I know Rod talked quite a bit about multifamily as a team sport, right? And this is why. Look at all these things you need money for. Obviously, to buy the property, you got to pay your acquisition fee. Who gets the acquisition fee? The GP, right, the sponsor. All of you guys who end up finding your own deal, your first deal, putting it under contract. You're doing all that hard work. You're finding the investors. You're finding the lenders. You know, you've got the relationship with the brokers. You got to be compensated for that, because a lot of times the sponsors, they get paid at the beginning and they get paid at the end. And we'll talk about that in a minute. Financing costs. It costs money to borrow money, obviously. Capital improvements, operating capital and reserves, closing costs, down payment. All of this turns into what's called your capital stack. And when you guys are underwriting your deals and you're figuring out your financial model and you're making sure this deal works for you, you want to make sure you know what we call the sources and uses. What every dollar that's coming in and going out, where'd you get it and what's it going to be applied to? That's going to be important for you to know to make sure that the deal works, but also for your investors, which we'll talk about, and your lenders. So what is a syndication? Broadly defined, it's organizing a group for a common purpose to promote a common interest and carry out a particular type of business. You know, people syndicate a lot of things other than real estate deals. You know, you can syndicate purchasing businesses, you can syndicate a lot of different things, but the nuts and bolts of it is that it's essentially a partnership between investors and a manager who combine their skills, resources, and capital to purchase and manage a property they otherwise couldn't afford. So you on your own you don't have the capital to buy a $5 million property. But if you find other investors that can invest with you and put in the equity required, you could purchase a $5 million property that way. In a syndication, typically the sponsor of the deal, that's the GP, and we'll look at GP-LP splits in just a minute and how that's structured. That's who's responsible for finding the deal, underwriting, coordinating the financing, developing the business plan. That is what justifies you getting your acquisition fee at closing. The investors put in the capital, the sponsor manages the property and manages the asset.
Todd, 1 second, brother.
David Jackson, please meet me in the back of the room.
We got a
Thanks,
lost
buddy.
child?
Thanks, buddy. Yeah.
Okay. Okay, so how are these deals structured? This is kind of a simple structure, right? This is the investment LLC. That's usually the property that is going to take title to the asset. So, right, when you get a deal under contract, you can put it under contract under whatever asset you want to use. If you're ever, or you can put it in your personal name even. You know, whoever the buyer is on the contract really doesn't matter. It's who the buyer is when we close the deal that is going to be important for you and for your lender and for your investors. The manager LLC is your GP portion. And that could be you individually, it could be you and your partner, it could be you and 3 or 4 different partners that are going to split the promote. We'll talk about that in a minute. The investors are putting money into the investment LLC, and in exchange, they're getting cash distributions. And again, based on your financial modeling, based on how the deal is structured, whether it's a heavy value add or whether it's a cash cow, you need to tell your investors, are you going to be paying them monthly, quarterly, or maybe not for 12 to 18 months? We've got a couple of deals where, you know, it's a heavy lift, you know, 40 down units out of 50 property, 50 unit deal, and the investors aren't going to see money for a long time because all that cash is going to go into rehabbing the property. See if I can go back. All right, so simple. This is a simple org chart. This is a complicated org chart. It's like a spider web. This is one we're doing right now at the moment, and as you can tell, it's complicated. And you'll see these two entities. I don't think this thing can point. Rod, do you have a pointer? Wow, that's all right. So we've got these two entities. You see the limited members, right? Those are the limited partners investing into these deals, and then we got the manager groups. Those are basically, this is 2 separate sponsorship groups that are coming together to take down 1,000 units in Texas. And in this particular deal, there's private equity money involved, and so this is a complicated one. Again, start with something like this, okay? Start with something simple, and you'll get to this. Who are the members of the company? Who are the members of the investment LLC that we talked about that takes title to the property? Again, the wording of how these are classified, it really doesn't matter. We typically call them Class B members, Class A members. Your investors like to feel special, and so we call them Class A members because they're more important than the Class B members because they're putting in the money, right? The Class B member is the individual sponsor or a sponsor entity. The Class B member controls the company, is responsible for the management of the company, responsible for management of the asset, and they own a percentage of the equity. We talked earlier about GP-LP split. This is what we're talking about. And this is a quid pro quo with investors, right? Investors put in the cash, you're putting in the management and the sweat equity of managing the property, managing the asset, hopefully executing on your business plan, and returning a huge profit to your investors. That's the quid pro quo. So in exchange, you're going to get a portion of the cash flow profit at the end of the cycle when you sell the property, typically between 25 and 40%. I would say the typical split is 70-30. 70% to your LP investors, 30% to you as the sponsor. So if you have a deal, you execute your business plan, the next thing you know, there's $1 million left over after you've paid all of your expenses, you've paid off your debt, you've paid all your preferred returns back to your investors. What happens to that $1 million? Well, typically you want to reserve some of it for miscellaneous AP, accounts payable that may show up on the property, and you got to pay for your tax return and stuff like that. But generally, that's $700,000 of that money is going to go to the LPs, and it's going to be split what's called pro rata, meaning split in accordance to who put in the amount of money. And then 30% of it, say $300,000, is going to go to the Class B member, the manager of the property. That's why I was saying sponsors usually get paid on the front end and the back end. They get paid on the front end when they charge their acquisition fee, which is usually 1 to 3% is kind of high, 1 to 2% of the purchase price. Okay? So if you've got $1 million deal, you're going to charge a 2% acquisition fee. What is that, $20,000 for your fee? And then on the back end, they get paid the promote, is what we call it, which is the upside, the split of the profit from 70-30. The Class A members, these are all limited investors. They subscribe to the membership. They execute what's called a subscription agreement. They sign the operating agreement. You're going to deliver them a PPM, which we'll talk about in just a minute. And the subscription agreement is akin to a purchase contract between an issuer and a subscriber. Okay? And these investors have no voting or management control at all in the company. They're purely passive. Okay? All they're doing is giving you money and receiving their dividend, called a dividend, or receiving their preferred return, and then they're receiving a split of the cash, the majority of the cash flow, upon execution. Now, typically, there's a preferred return offered. Let's see what the next one is. Okay. There's a preferred, what is a preferred return? A preferred return is an offer to an investor to pay them a percentage on their capital contribution based on the amount of capital they put in. It can range between 6 to 10%. And again, this is based on your modeling, based on the underwriting you learned how to do at this conference. And if it's a healthy deal, you're going to pay 7, 8, 9%. You know, if the modeling can support that. So, for instance, if you have an investor that paid $100,000 to you, wired in $100,000, and you're offering them an 8% preferred return. So that means every year you're paying that investor 8%, $8,000 on their money. Okay? And you can pay that to them quarterly, you can pay it monthly, you can pay it annually. You know, we spell that out in the operating agreement, how often you pay it. Typically that preferred return will accrue as well. So if you have a heavy lift deal, when I say heavy lift, I mean one that requires a lot of construction, you've got a lot of down units, it's going to take a lot of rehab to get it back up to where you can actually rent them out. In those kind of deals, they may not get a return because, again, all the cash is going into rehabbing that property. In that instance, if you don't pay them $8,000 in 1 year, well, that's going to roll over to the next. They don't lose it, right? It gets rolled over to the next year. So oftentimes, if you don't pay them any preferred return for the entire life of the property, the life of the investment, when you pay them at closing, you're going to catch all that up, right? They don't lose their rights to that preferred return. The remaining cash flow is split between the sponsor and the investor. Typically 70% we talked about to the investors, 30% to the sponsor. Again, that's a simple way to do it. Most deals I think are pretty simple. We have some clients in some particular deals where the GP wants to incentivize, they want to be incentivized to really make sure the property is performing at its peak. So the way they do that is we can structure what's called a waterfall in the operating agreement. And what that basically means is the investors are going to get, say, 7%, and it's a 70-30 split. Well, there's a concept called IRR. I don't know if you guys have talked about that or not, but it's called internal rate of return. It's kind of a metric that we use to just identify the health of the investment. And it's a calculation based on their capital contribution and the returns that they've received to date. If the IRR gets over a certain hurdle, that 70-30 split then tilts in your favor. So if you're offering an 8% preferred return, and then their IRR hits 10%, well, now that 70-30% becomes 60-40. And now you're getting 40% of the promote at the end.
Thank you for talking about that. I completely forgot to talk about hurdles. Thank you.
Okay.
Yeah.
Good.
Thank you.
Good. So again, it gets to 60-40. Well, then say you get to a 12% preferred return, or even 15 IRR. Sorry, the IRR calculation. Then that cash flow splits maybe 50-50. Now you as the GP, you're incentivized to really push rents. Make sure you're increasing the rents. Make sure you know the market to understand what are the market rents in this area. Maybe you need to turn over the whole tenant mix to get a whole new batch of tenants in there because you've upgraded the property. Increasing your rents and decreasing your expenses are the two ways you're going to increase the cash flow and increase your returns, right? So again, that's easy for us to document. It's just make sure it's included in your underwriting if that's the way you want to go. Just recently, I have a client that structured the waterfall where it actually tilts, where the GP's getting 65% of the cash flow and the LPs are getting 35% of the cash flow. I looked at him and I said, you sure about this? Because most of the LPs I know and work with would not accept that return, because really the LP's putting in the most of the cash. They want to be able to get the most of the profits, but he said no, his LPs will do that. So I said, okay, we'll draft it that way. Hey, here's a good example of just how the split flows. So there's the property address, the newly formed investment entity. You've got LP investors putting in this instance, 65% of the cash. The manager entity, which is made up of 3 sponsors, right? So that's 3 guys, 3 individuals who got together at this conference, and they're going to say, let's go take down a deal. How are we going to work out the split of the manager entity? Well, here's an example. The 82% member is a guarantor, because he's the primary manager of the property. He's the primary conduit between the lender, and then the other 2 sponsor members. One is not a guarantor in this instance. The other one is a guarantor, and I'll just tell you, for this example, it's to meet certain net worth and liquidity requirements that lenders have. To take down larger deals, you usually have to have a net worth equal to the loan amount and liquidity of about 10% of the loan, just depending on what type of lending you're going after. But this is an example of how the cash flows in that particular instance. So we're here to talk about securities. That was kind of a lead up about how deals were structured. Well, how do we know if we have to comply with securities regulations? Again, this dates back to a Supreme Court case from 1946 that defined what an investment contract is and what elements need to be present to know whether you need to comply with securities regulations or if the type of investment you structured doesn't. So is there investment of money? Is there a common enterprise? And this is the big one. Are the expectation from the investors of the share of the profits solely from the efforts of the promoter? And in this instance, the promoter is the sponsor, the manager is you that's going out and finding deals and raising money. In that instance, the SEC is going to consider that a security, right? And if it is a security, it's considered an investment contract, and then you have to decide, we'll decide for you, whether it complies with a certain exemption under the securities regulations, specifically Regulation D of the Securities Act of 1933. Okay, now we're not talking about IPOs, right? We're not talking about public offerings. These are all private offerings. So there's a big difference. Public offerings are, Uber goes public, right? That's a whole process of registering with the SEC, lots of paperwork, because that security opportunity, that opportunity to invest in that company is open to the public then. And so it's a whole set of different rules. This is considered a private security and a private offering, and such, there are exemptions that allow you to make this offering as long as we file certain things on your behalf and form the company in certain ways. This is a good kind of decision tree. Let me see if this next one, okay. So this is a good decision tree to kind of just think to yourself, is it a security or is it not? Is it managed or managed? Most of the companies we form, the LLCs we form for purposes of buying real estate, are manager-managed. That means you have a manager entity and you have your investors. The investors are members of the company. The Class B manager is a manager of the company, is the manager of the company. In that instance, it's generally going to be called a security, considered a security, because again, like we talked about earlier, the expectation of profits is solely from the efforts of the promoter, in this instance, the promoter being the manager. Now, what if it's member managed? You know, there's also the joint venture concept. And what is the difference between a syndication and a joint venture? I get asked this question all the time. And it's easy to explain, but sometimes it can get a little gray depending on how many people are in the joint venture. So a joint venture is 4 of you decide to get together and go buy a piece of property, and you're each going to put in, $100,000, and the company is going to be managed by all of you, and you'll designate one managing member, but all the decisions are going to be made unanimously. So you all have voting control, and you all have certain responsibilities within the company. That's generally going to be considered a joint venture, and you're not going to have to worry about securities regulations and filing Form D and the things we'll talk about in a minute. Now, in that same scenario, even in that same scenario, if all of you put in $100,000 apiece, but 4 of you are passive and one person is managing the company and doing everything, and the other 4 just say, just pay me my check when the time comes, that'll generally be considered a security, and you've got to comply with securities regulations. Now, if you're complying with securities regulations, there's 2 types. We talked about IPOs, large public offerings earlier. The world we live in is Regulation D, exempt offerings from SEC registration. There's 2 types. There's what's called 506B and 506C. And the actual statute is, Regulation D of the Securities Act of 1933, and the 506C is a subsection.
Hey, Todd.
Yeah.
Can I ask you a quick question? I overheard just the last little bit about your joint venture description, and I told them, I did joint ventures when I was in my 20s where they put up all the money, and we split them 50-50. I did all the work, and we split the profits, but they were joint ventures because they signed on debt. They were active in the deals, right? Mm-hmm. Okay, so you don't have to put money in to do a JV, but everyone has to be active. Sorry I interrupted.
That's right.
Okay,
That's
thanks,
right.
bud. All right.
Yeah, so if you're signing on the debt, then that's taking an active role in the company. That's exactly right. All right, so the difference between 506B and 506C. 506C just came into existence 5 or 6 years ago. I'm not exactly sure when. But prior to that, it was 506B, and 506B is the exemption you're going to rely on. But what the SEC came up with is they said, look, we want to limit the amount of sophisticated investors you can have in your deal. What is a sophisticated investor? Well, the SEC doesn't really define it. And they do that on purpose, right? Because they want us to try to figure it out. And they don't want to give us a hard and fast, bright line rule. But a sophisticated investor is generally somebody who has knowledge. Everyone in here is a sophisticated investor just by coming to a program like this, right? Generally has knowledge about real estate investing and is sophisticated in that topic, okay? But there's no advertising. So your investors in a 506B syndication, you cannot advertise to them. So you can't go put it on Facebook or have a webinar and invite the public to come and watch your webinar and then take their money. That's gonna, if it's a 506B syndication, that's going to not comply with that particular regulation. Well, then the private equity world started petitioning the SEC and was saying, well, we want to be able to advertise these deals, and again, the SEC wants to protect investors, but they also want to spur the economy with private investing, right? Private investments. They understand there's a kind of a fine line they're walking there. So they came back and said, okay, we'll create another regulation. We're going to call it 506C. And in this particular regulation, you may only have accredited investors in your deal. And we'll talk about accredited investors in just a minute. So no sophisticated investors are allowed, only accredited. And the deal that they struck kind of with the private equity community was that, okay, we'll let you advertise them. Because the thought is if you're only having accredited investors, and these investors are generally going to be considered highly sophisticated, understanding the deal, and so we'll allow you to go advertising. So if you guys are seeing these advertisements on Facebook and you get an email blast from people you don't know and they want saying invest in our deal, it should be a 506C offering. One important thing to remember, 506B, you need to have a pre-existing substantive relationship with the investor. Again, not a term that's really defined by the SEC. We've looked, there's no action letters that the SEC has put out. There's case law that we've read to kind of read the tea leaves to figure out what that means. For 506C, you don't need to have a pre-existing relationship. You can do a webinar at Buffalo Wild Wings and bring all your, everyone you may or may not know and get investors that way. So this is the difference. The main difference, 506B, limited to 35 sophisticated but non-accredited investors. You can have unlimited accredited investors, all right, but you must have a pre-existing relationship and no advertising. 506C, only accredited investors, no sophisticated investors, and you are allowed to advertise. When I think of sophisticated investors, I think of if your neighbor is a retired school teacher and came into a lot of money because of some estate planning, and you go to her and say, hey, you want to invest in my deal, she's probably not sophisticated, right? I'm assuming. Just as an example, what is an accredited investor? All right? Well, there's individuals that may invest, and there's also entities that may invest. Okay? And you guys are going to get a copy of this presentation. I think it's in your workbook. An individual has to have a net worth of $1 million or more, excluding their primary residence. That's an important one, too, because if you've got a lot of equity in your house, you can't consider that as part of your accreditation status. Or a $200,000 annual income individually, or a $300,000 annual income if you're married.
Todd, 1 second, brother. Sorry. We didn't have the handout for him either, did we? Frickin' FedEx. Yeah. Listen, guys, if you don't know, in the back of your books is there's supposed to be, a QR code to your resources. Hopefully you saw that, right? That's where all your resources are, and that's where this PowerPoint is.
Oh, good.
We'd hoped to have physical copies, and I told you what happened. Anyway, sorry to interrupt.
No worries, and I'm happy to email it to everyone in here as well.
All right, yeah.
Entity, net worth of $5 million or more. Now, if you form an entity to invest in a deal, we're going to look at the individual members of that entity to determine if they're accredited or not. And all other investors, if you don't meet the definition of an accredited investor, you're considered unaccredited and sophisticated. One thing I forgot to mention back here, this is another, most of our clients will do a 506B offering for two reasons. One, most of their investors are sophisticated. They're not all accredited. And for two, there's less burden on you as the sponsor to ensure that the investors are accredited. And we'll talk about this in a minute, but part of our process when we're processing the paperwork for these offerings is we have what's called an investor questionnaire. And the investor questionnaire, you send it to your investor, fill this out. It'll have checkmark boxes of, yes, I've got an annual income of $200,000, or I've got a net worth of over $1 million. And you as the sponsor, you have discharged your duty, as far as the SEC is concerned, to ensure that these guys are accredited. There's nothing else required of you in a 506B offering. In a 506C, the SEC takes it one step further and says, well, you can't rely on self-certification. So you have to take it a step further, and you actually have to document the accreditation. And what that means is you need to ask for a bank statement that shows $1 million in the bank. You need to ask for a W-2, their brokerage account, whatever information they want to give you. And a lot of GPs don't want to ask for that information because it's personal, right? You don't want to ask for that. But if you're going to do a 506C offering and you want to advertise, you're going to have to get that information. I think what a lot of our clients will do is they hire investment software that has that process built in, like Juniper Square, Appfolio, some of these other companies that you can pay to manage the investments and manage all the documents are in that portal, and then you kind of have a buffer between you and your investor. And so Mr. Investor or Mrs. Investor, I'm not actually seeing this information, but my investment software company is going to ask for it. That's just another distinction. Accredited investors, pre-existing substantive relationship. What exactly does that mean? We did some digging just to see if there is any hard and fast rule, and there's really not. There's just sort of elements and things that you need to consider. The relationship must exist prior to the commencement of the offering. There's no set minimum amount of time that a relationship must exist before considering it pre-existing. So the way I think about this is, if you do a webinar and you want to put on an educational event and invite investors and talk about deals, have one of these meetups. I've done a lot of work at meetups and spoken at meetups where we've talked about deals. If an investor comes to you after that meetup and says, hey, I want to invest in this deal, and it's a 506B offering that you have, you can't accept their money, but what you can do is take their business card, go to lunch with them the next month, keep them on your email list, and develop a relationship with them, so then the next deal that comes, you can offer it to them because you have that pre-existing relationship. The time must be sufficient between establishing the relationship and the offer so that the offer is not considered made by general solicitation or advertising. And again, a lot of this is just stuff that we found in looking, kind of, like I said, reading the tea leaves from the SEC and from case law. There's been some newly added categories recently about what is an accredited investor. And again, the SEC wanting to spur the economy, wanting to not stifle private investment, because they realize that that's a big part of what's driving our economy. So they want to broaden that definition of what an accredited investor is. So these are just some additional items to consider. If you've got a Series 7, Series 65, or a Series 82 license, the SEC may consider you sophisticated or accredited regardless of your net worth standing. Knowledgeable employee, this is an interesting one. Again, this is talk about lobbying from the private equity industry, but this is knowledgeable employees of a private fund, but only for the investment of that in that specific fund. So a lot of institutional investors will have their own fund and their employees want to invest in it. Well, they'll allow you to be accredited in that instance. And spousal equivalence included in the net worth tests. And then entities, what's an accredited entity? So an LLC, SEC or state registered investment advisors who may qualify if they have excess in $5 million, as long as they're not formed for the specific purpose of investing in a deal. So I've come across this a couple of times where a group will get together and they'll pool their money together and they'll want to invest, and they have over $5 million in their LLC, but they formed it for the specific purpose of investing in the LLC. And we'll have to advise them that you're not going to be considered accredited in that instance. Indian tribes, I'm not sure how much that would apply here, and then family offices with at least $5 million in U.S. assets under management, and their family clients would also be considered an accredited investor. So we talked about what's a sophisticated investor. Defined by the SEC as someone who has sufficient knowledge and experience in financial and business matters to make them capable of evaluating the merits and risks of the proposed investment. Again, that's a very broad brush that can be interpreted a lot of different ways, but generally this is what the SEC considers a sophisticated investor. And like I mentioned earlier, not your typical neighbor down the street who knows nothing about real estate, that just has a lot of money. So just be careful when if you're approaching someone like that and trying to have them invest in your deals. So part of the documentation we prepare as securities attorneys and doing real estate deals with our clients is what's called the PPM. This is another acronym for Private Placement Memorandum. And again, this is a CYA document, right? A disclosure document that you're going to give your investors to ensure that they know all of the risks associated with providing an equity investment to private individuals, right? And even your public investments, if you guys are buying stocks, on the public market, that prospectus that you received is the same thing. This is just what it's called in the private industry. What is in the PPM? It's a very lengthy document. You know, it could be anywhere from 30 to 50 pages, because we've got to put a lot of stuff in there, because we want to protect you and make sure these investments are sound and make sure that the investors know all the risks associated with it. So we're generally going to describe the business plan. We're going to describe the terms of the offering, like we talked about earlier. Is it an 8% preferred return, a 6 or a 7? What's the split between a GP and LP? All of that needs to be defined in the PPM. If there's any conflicts of interest, a lot of times our clients have their own management companies. So they're buying their deals and they're self-managing. There's nothing wrong with that, but it's just you need to disclose that potential conflict of interest to your investors. Suitability standards. How is an investor qualified? This I'm going to get to the big ones in a minute, but distribution and fees. How are we going to be? How's the cash going to be distributed? The property information. What's the property we're investing in? Give us the detail on the location. And a lot of this stuff, I'll tell you, we can pull directly from the broker's offering memorandum, right? You get a deal from a broker and it's got all this financial data and all this market analysis. We can pull some of that and put it into our PPM. The voting rights, liquidity, dispute resolution. I would say that the biggest, from our perspective, the biggest thing that we want to make sure we're 100% correct on in the PPM is the sources and uses and the fees. Because the last thing you want is an investor running to the SEC or running to the state securities board equivalent, because each state has their own securities regulatory body, and filing a complaint against you because you didn't tell them you were getting a $200,000 acquisition fee on the closing sale. And that money, those fees that you're paying to yourself is being raised from private investors, right? So we want to make sure that's disclosed in the PPM. And also the sources and uses. I would say those are the two biggest items. Again, that comes from our financial model. It comes from our underwriting. What loan are we getting? Who's our lender? What's the term? What are the repayment terms? Again, very important information to have in the PPM. And then the risks. A lot of the risks are boilerplate, but depending on the deal, we want to put in certain risks. Like we talked about earlier, if it's a heavy lift, there's substantial construction risk. We've had to adjust a lot of our PPMs in the COVID era to say there could be government shutdowns that cause us to, stop operating this property, or evictions. Oh my gosh, I've dealt with so many eviction problems because of COVID and because of the moratorium. That needs to be in the PPM, because if you can't evict people and get new tenants in there, guess what? That's going to affect your bottom line, and your cash flow is going to be hurt. And you may not be able to pay your investors back. Got to have that in the PPM. Very important document. And I would say in 506, we do a PPM for every deal, either 506B or 506C. There is a thought out there that you don't necessarily need them in a 506C, because remember, that's only accredited investors, right? So your investors are all very accredited, very savvy in financial and real estate matters. So you may not necessarily need one. Our advice, always have one, because again, it only protects you in the event something goes wrong. 506B, you absolutely have to have one, because you're taking money from a sophisticated investor, and the SEC wants to make sure you're disclosing all these risks. We talked about this earlier. How does the sponsor make money, right? You're all in this for the financial value you get out of it. Well, how are you making money from these deals? There's lots of ways. At closings, you're going to get paid an acquisition fee, typically. Acquisition fees typically between 2 and 3% of the purchase price. So the bigger the deal, the bigger your acquisition fee is. Now, when you get up into the larger deals, that fee will go down, because your investors are not going to appreciate you making, $500,000 on a deal that they're paying for, right? There's asset management fees that are baked into the operating agreement. Again, when I say baked in, they're in the operating agreement, but they're also disclosed in the PPM. And the asset management fee is to that's to compensate you as the sponsor for, providing investor reports each month. You're going to have to tell your investors that how's this property doing? Managing the property manager. Even though the property manager is managing the property, who's managing the property manager to make sure you're executing on your business plan? Because it's the property manager that's going to increase rents, right? They're the one that's signing new tenants. So we got to make sure they're doing their job. And you're going to get compensated for that. And it's usually 1% to 2% of gross receipts. So when you're underwriting deals and you're looking at 3.5%, 4%, 5% for a property management fee, add another 1% for your asset management fee. You can charge refinance fees and disposition fees. I know a lot of my clients won't do that because it seems a little overkill. But some investors are okay with it, and if they're okay with it, then you can certainly charge it. Distribution of cash flow and profits, like we talked about earlier, there's going to be a split of cash flow either upon a capital event, which is a refinance or a sale. We're having a conversation out in the lobby with the gentleman about, well, and this is a good point. Well, say your investor invests $100,000 and you go for a refi, and you pay back $50,000. What happens then? And you're still paying a preferred return. If you're paying an 8% preferred return on $100,000 to your investor, you're paying them $8,000 a year. If at a refinance you pay them back $50,000, you're now only paying 8% on $50,000, not the full $100,000 that they invested, because you're only paying it on their capital account. So your accountant will establish a capital account for each investor, and will track that. And that was a good point to bring up, because we were just having a discussion with him about how that works. And it's important to know when you have a refinance, you're returning, it's a return of capital, not a return on capital, right? So that's a very big distinction. Let's see. Ready to make an offering. What do you need to do? The first document that you guys will prepare once you have a property under contract, you're ready to raise money. As the broker sold you on the property, you need to sell your investors on the deal. And so you need to create an offering memorandum that would tell the investors about the deal. Tell them about the market, just like the broker, right? Tell them about the market, tell them about the opportunity, tell them what you're looking for, tell them how much you're going to make on it, right? And tell them your business plan. What is your business plan? When are you going to sell? And what's the one thing the investor wants to know? Don't lose my money. And when are you going to get my money back? Right? Don't lose my money is the very most important rule. Solid business plan, financial pro forma. What's the exit strategy? And again, that's market driven. Are you riding the supply demand in the housing industry right now? Or is it a management play? Is it an out-of-town manager who's just doing a crap job on this property, and you put someone in a local, you'll be able to reduce the expenses? You're going to give them the operating agreement, you're going to give them the subscription agreement, you're going to give them the PPM. They're going to give you back the signed subscription agreement and the signed operating agreement. What's your plan? How are you going to find these investors? Well, they're all here in this room, number one, right? That's the biggest benefit of coming to events like this. That's right, right? That's right. They're right here. I hope you guys got as many business cards as I did, right? Build that investor database, okay? Where's Garrison? Garrison is here. You guys talked to Garrison yet? That guy has about 150,000 people in his CRM. Unbelievable. From coming to events like this, right? Attend monthly investor meetups. Start building your brand, right? Build your credibility in this market. I always give this advice to people interested in getting into this world. Invest in other deals as an LP. To build your credibility, to build your track record. The number one thing brokers want to see if they're awarding deals is a track record. And the number one thing lenders want to see when they're lending you money is a track record. You can't it's just hard to break in, right? So invest in other people's deals, because then you're an LP and you've got that track record. You can start then, and then you can get in potentially as a GP. Build your team based on the skill set. This is, Rod preaches this day in and day out, and it's so true. Multifamily is a team sport. You need all of these individuals on your team to be successful. This is a good slide. This is from a client of mine in a deal that we closed in Florida a couple years ago, and I wanted to just show it as kind of a timeline of, when the PSA is executed to closing, right? Like, again, it's a marathon once that deal's under contract, because we've got a lot of work to do between the effective date and the closing date. So here it's around March 23rd. I think we were closing in July. Yeah, so about 90-day contractual period. Final due diligence was completed May 16th. May 27th, my marching order say, Todd, give me the PPM by this date, because we're going to give it to our investors. You got to have an LP commitment deadline. You got to know from your investors, are you ready to commit to this deal or not? And a lot of sponsors, what they'll do is they will send out email blasts, again, building that database, and they'll have built in the email that they get, you can click, I'm interested. You can just do what's called soft commitments. So you can kind of test your investor database. Got a great deal. If you're interested in a soft commitment, press here. And then when it's time to actually commit, right, the hard commitment, they're signing the subscription agreement. That's been issued. The capital funding, again, we want the money to be funded into escrow prior to closing. And it can either go to the title company, or we hold escrow for a lot of our deals, and then we'll wire it to the title company. And then the final transfer of funds and the acquisition occurred on July 3rd. I just thought it was, again, this is a really good, we talked about sources and uses for this particular property. There's the purchase price, the CapEx, operating reserves, there's the acquisition fee. Look, $167,000 they got paid. Closing costs, and then there's the total uses.
I am so sorry about this, guys. I can't tell you how frustrated I am right now, but this is in your resources, so you can study this later. Again, my apologies.
What, the hard copy's not there? Oh.
The fact they can't see it, and they were supposed to have printed copies, and FedEx, I'll own it. We screwed up. That's it.
No worries.
FedEx screwed up, but I'll own it. Like I told you, take 100% responsibility, right? All right, sorry I interrupted.
No worries. Again, I'll get the email list, and I will email it out to everybody.
Yeah, honest. Awesome. Thank you.
Yeah, absolutely. Again, we talked about sources and uses. There's the uses. What's the sources? Well, debt financing. I don't know what that percentage is, but again, most of the capital required to buy this property is coming from debt. GP equity, $1 million. LP equity, 1.6. And in this instance, they got a credit from closing. And again, look at the long-term stability strategy, right? The general partners in this particular deal are contributing $400,000 of their own money to cover additional closing costs. Most investors that you will encounter, the first question they're going to ask you is, well, how much are you putting in, right? And you need to be able to answer that question. You need to be able to answer it honestly, and hopefully the answer is, well, I'm putting in whatever you're putting in, right? It could be I'm putting in 10%. I'm raising 90% from LPs. That's a completely satisfactory answer in my view, because again, the sponsor's doing all the heavy lifting, all the sweat equity, but we're putting in 10% of the capital. And most, if not all, lenders are going to want to see actual skin in the game as well. It's going to be hard. You're going to be hard pressed to find a lender that's going to lend you money and you don't have any money in the deal. That's it.